Okay. All right, let's go ahead and proceed.
Well, Your Honor, there are a few motions set. I know that we filed them separately on the defendant's side jointly. We've got one motion to strike and or limit the testimony of 4 purportedly non-retained experts the plaintiffs have designated, and then a motion to strike the testimony of Dr. Ongeko, which is who they claim is their sole retained testifying expert. And I understand that plaintiffs have moved to strike one of our retained testifying experts, Dr. Modal. So if you'd like, we can begin, and probably makes the most sense to start with the 4 non-retained experts.
Okay. Go ahead.
So, Your Honor, as you know, this is a unique products liability case, and the plaintiffs claim that Mr. Neil Harris died from oral cancer that he contracted by using 2 e-liquids, one called Sucker Punch and one called Mother's Milk. And we're here today because, unfortunately, there's no way under the current science and data available for the plaintiffs to establish causation. As you know, in a products liability case, the plaintiffs need to establish general and specific causation. And what they are trying to do is skip past the general causation standard and try to get right to the specific causation standard, which you can't do when there is no supporting documentation, studies, etc., to establish that the circumstances of Mr. Harris's injuries are similar to those under the reliable studies that establish general causation. Now, with respect to these 4 non-retained experts, 2 of them are dentists that treated Mr. Harris, and 2 are physicians that treated Mr. Harris. These 4 experts were designated similarly, identically. This is what they designated them as. Plaintiff's treating medical provider. This expert may testify regarding the expert's examination of plaintiff's diagnosis, the treatment of plaintiff, the reasonable and necessary costs of that treatment, plaintiff's prognosis, plaintiff's medical records and bills, future medical care required, and the costs of that care. This expert's mental impressions and opinions are set out in the medical bills and records. That's for Dr. Garza, Dr. Carter, Dr. Arambide, and Dr. Mons. Nowhere in the medical records and bills do any of these purported experts make any conclusions as to whether vaping, whether generally or specifically to the products at issue in this case, had anything to do with his cancer. It's not there. So the designations themselves, they should not be permitted to proffer the testimony that they tried to introduce at their depositions, which was each of them attempted to state that it was their belief and opinion that Mr. Harris, his use of vaping devices and e-liquids caused his cancer. So at the outset, they should not be permitted to testify as to any causal link between vaping and his cancer because it wasn't contained in those medical records and bills. On top of that, Dr. Carter, I don't think it needs to go any further than this, Your Honor.
Let's do this. Let's go through them one at a time. So first is Dr. Garza, who's a dentist.
Yes, Your Honor.
Correct.
Dr. Garza. Let me just read a question and answer from his deposition. Question. Okay, I guess, would you say that you're qualified to give an opinion on whether vaping causes mouth cancer? Answer. No, I'm not qualified to do that. Dr. Carter. Question.
Well, we're doing Dr. Garza first. So is that the whole basis of your motion to strike Dr. Garza?
Oh, no, Your Honor. So the basis is, first, he's admitted he's not qualified to give that opinion, plainly. Okay. So he shouldn't be able to offer that opinion. Secondly, of course, his training, education, and background, he has no experience, no expertise in the areas of epidemiology, et cetera, which would give him the qualification to testify as to whether anything in e-liquids, again, whether generally or specific to these products, caused Mr. Harris's cancer. He doesn't have the background. He read a few articles because he was interested in it, but it admitted then, of course, that he can't come to that conclusion.
Okay. Response as to Garza.
Yes, Your Honor. Thank you. So I think a quick background would be helpful here. So there are three general categories of evidence for general causation. So one, we have the formaldehyde and acetaldehyde body of evidence, and that's largely based on, well, I shouldn't say largely based on, one of the big articles in that body of evidence would be the Stevens article. That was 2017, cited in our opposition. That showed a 10.7 times increase in cancer risk based on e-cigarette use as compared to nicotine inhalers. And the study also noted that the cancer risk for, or the cancer potency of nicotine inhalers is beyond that of ambient air. So the Stevens article shows pretty clearly that the risk of cancer based on e-cigarette exposure is well beyond 10.7 times that of ambient air. So that goes to general causation. That is in line. We cite a number of other articles in our papers. There's a whole bunch of them out there. We cite Kosmider, Klager, Jensen, Wang, all studies that show when you heat the ingredients of defendant's product, that releases, which is propylene glycol, vegetable glycerin, that releases acetaldehyde and formaldehyde.
Now, you may want to slow down just a little bit because some of those, I pronounce some of those words more slowly so that I can.
Yes, thank you. I appreciate that. So the two words I've been using largely are formaldehyde and acetaldehyde, and the ingredients are propylene glycol and vegetable glycerin. So that's the first category of evidence. Again, formaldehyde and acetaldehyde, these are not new chemicals. They are well established to be carcinogenic. The Stevens article gives us that 10.7 number, which it's going to be much higher in this case, but for general causation alone, we're looking at 10.7 times increase. We also have the literature regarding DNA double strand breaks. Again, DNA double strand breaks, they are not new. They've been well researched. The U 2016 study shows that when exposed to e-cigarette vapor, e-cigarette users experience DNA strand breaks. DNA strand breaks are known drivers of cancer development. So that's the strand break category of evidence. Our third category of evidence is the gene dysregulation or gene deregulation. That is the Tomasi, T-O-M-M-A-S-I article from 2019. And that article found that cancer was a top disease associated with deregulation of genes.
Mr. Brennan, I appreciate you giving me some background, and that's helpful. What I'm really trying to look at is, kind of piece by piece. They want to exclude Garza because they say he's not qualified as a dentist to render opinions as to causation, and he apparently testified to say that he agreed with that. That wouldn't mean I would strike him as an expert. He could still testify about the injuries and all that kind of stuff, but it may be true that we need to strike him as to a causation expert. Are you trying to use Dr. Garza as a causation expert in this case?
Thank you, Your Honor. The answer to that is yes. I will say at the outset that I do think between if we had to rank them, between Dr. Garza, Dr. Carter, Dr. Mons, and Dr. Arambide, he probably has the least amount of experience that he can draw from to testify. But he has been practicing as a dentist for 47 years. Part of his job duties as a dentist are to identify oral cancers and refer out to treatment. He did read some articles, not only for his deposition, but also he noted that he read them because he's going to use that information to treat his patients. So this is not out of his wheelhouse. This is something that the association between e-cigarettes and cancer, that's relevant to his practice. And with treaters who have had their hands on the patient, who have looked at the patient, they are in a little bit of a different position to opine than a retained expert who's just basing their opinions off of medical records, if that, in literature. And I will note the Gamil case, citation 972 SW2D at 726. That gives a little bit of more information on treaters as experts. The experts can rely on their experience and training just as long as there's no analytical gaps. And so that's why I wanted to start with our general causation. There are articles out there, which again, Dr. Garza noted that he reviewed articles, and those articles show this association between e-cigarette vapor and cancer. So I would say, based on his 47 years treating people, looking to identify cancers, his research, and his hands-on experience with with Neil Harris, he is qualified. Now, I think the jury is perfectly capable of weighing his testimony against, say, Dr. Mons, who has been treating thousands of patients, or over 1,000 patients for cancer, for head and neck cancer specifically. But just because he may not have the same experience as Dr. Mons doesn't mean that he's not qualified. And to the extent that he said that he is not the expert, I don't recall specifically what the testimony was, but something along the lines of he's not the expert, he's not an expert. I don't expect him to be using that in the legal sense. I take that testimony to be, there's probably people who are more qualified, but that doesn't mean that he himself is not also qualified.
Mr. Bogdanovich, why don't you share screen the portion where you say he said he's not an expert?
I can do this, Your Honor. Does that help? I don't
Not
have.
really.
It's page 39 of his deposition. And again, specifically, it does read, question by Ms. Cruz. Okay, I mean, I guess, would you say that you're qualified to give an opinion on whether vaping causes mouth cancer? Answer, no, I'm not qualified to do that. And that's exactly what plaintiff's counsel is trying to step around. We're talking about if they want to have expert testimony about causation here in this case, you need to have someone who's got the background experience, training, et cetera, and relying on competent studies, et cetera, in order to come to the conclusion. You can't just say, I'm a dentist and I've treated oral cancer. What they have to establish is, did these e-liquids, specifically mother's milk and sucker punch, cause Mr. Harris's cancer? And in fact, but what I'd also like to note, Your Honor, is none of the experts in this case.
Let me ask a question. I mean, this particular litigation involving vaping is, relatively new, because vaping is relatively new, but we've had, years and years of cigarette litigation, and even more so asbestos litigation. Are there any cases that kind of talk about whether or not a dentist can be an expert in providing causation testimony as to the causal relationship between vaping between a product and cancer?
None that I'm aware of, Your Honor, particularly if the dentist,
Either
again, if
way.
they don't have the background. I'm not aware of any. I mean, he is a dentist. He has seen mouth cancers before, Your Honor, but this goes back to
we
what
only
they
have a
have to
limited amount
establish.
of time, guys. So, I have what I need on Garza. Let's go to the next doctor.
Yes, Your Honor. The next was Dr. Carter, who's also a dentist. And what I was saying earlier when we were getting into Dr. Carter, again, I think it should stop right here. Question. Let me just make sure for the record that your opinion that vaping causes cancer is speculation. Now, there's an objection to form. Answer, sure. Again, Dr. Carter, like Dr. Garza, does not have the background, has admitted his opinion is speculation. He's admitted he's done no in-depth research on e-cigarette use and the development of cancer. It's just not there, Your Honor. He's never conducted independent studies. And globally, this goes back to what I was talking about with general causation. All of the experts have agreed that while there are some studies, or I should say case studies, et cetera, that talk about e-cigarette use, vaping, et cetera, none of them are conclusory. There are no conclusory studies because the science isn't there yet. The data isn't there. In fact, Dr. Mons, the next expert we're going to talk about, admitted that it's going to take decades for us to get that science. They have to use what is existence right now. And unfortunately, it's just not there. They cannot get general or specific causation. There is no science to back this up. Dr. Mons and Dr. Arambide, though they want to say it was a substantial factor.
We're dealing with Carter right now, so response on Carter.
Okay.
Yeah, thank you, Your Honor. So quickly to hit that point, Stevens is conclusive that it establishes a link between oral cancer and e-cigarettes. And the testimony that we'll discuss with Dr. Mons, he was referring to longitudinal studies, which take decades, not any studies regarding the causation. Moving back to Carter, Dr. Carter is not only a DDS, he has his master's in microbiology. He's been a practicing oral and maxillofacial surgeon for roughly 30 years. He does continuing education relating to pathology. He's diagnosed several hundred people with cancer. He's treated about, I think he said, short of 10% of those several hundred.
Did he diagnose the plaintiff with cancer in this case?
He referred him to the oncology, the head and neck surgery department, first at MD Anderson and then at Cancer Treatment Centers of America, based on what he saw. He did not give the formal cancer diagnosis, correct?
Who's the next doctor? Dr. Mons?
Yes, Your Honor.
All right, go with Dr. Mons.
Your Honor, Dr. Mons, again, similar, almost identical. When we're talking about these studies
Is he also a dentist?
No, Dr. Mons is a physician.
What kind of physician?
He treated Mr. Harris at the Cancer Treatment Centers of America in Oklahoma. Now, when questioned again about the link between vaping and cancer, we're talking about the studies. Dr. Mons, question: there are no studies that have shown that vaping in humans causes cancer. Is that true? Answer: that's true. All of the studies and articles that any of these physicians and the dentists have reviewed, none of them were as conclusory as plaintiff's counsel has said. These experts have admitted that much, that there are no articles or studies that conclude that vaping in humans causes cancer. In fact, Dr. Mons, again, physician, next question. And so your opinion that vaping causes cancer is essentially, at this point, a hypothesis. Is that true? Objection to form. Answer: yes. And the same for Dr. Arambide. The articles that they reviewed, the studies that they reviewed.
Wait. Let me go ahead and roll. I'm going to deny the motion to strike as to Mons. Who's the next one?
Dr. Arambide.
Okay.
Dr.
How do you spell
Arambide
his
was
name
also
for the court reporter?
Arambide.
Okay. All right, go ahead.
So Dr. Arambide also treated Mr. Harris at the Cancer Treatment Centers of America. Dr. Arambide admitted she's not a specialist in head and neck cancers, that only 5% of her practice has been with patients like that.
As well. She's an oncologist as well.
Yes. She reviewed 11 articles in support of her conclusions, did research for 3 hours, never spoken on this topic before, and admitted that when she reviewed these articles, she said, none of the articles or literature she reviewed state there is a known association between e-cigarette use and cancer. It's just a conclusory opinion that it substantially caused his cancer. They don't have the science. Dr. Arambide admitted that in her deposition.
Do you agree, Mr. Ringen?
I do not agree, Your Honor. I mean, the Stevens study is attached to our opposition. The literature is what it is. It's right there. And I will say that the experts that are being pulled out of these, multiple hour-long depositions where there's one question about, that's again taken out of context. I don't think that gives a full assessment of the entire deposition.
All right, so I'm going to deny the motion to strike as to Mons and Arambide, I guess. As to Garza and Carter, I'm going to grant the motion to strike as to causation. The experts can testify about treatment and everything else, unless you can find me some case law where in some of these other areas, a dentist has been able to testify as to causation. And even then, I would say probably not, since they never diagnosed cancer. So I don't think they have the ability to testify about causation, but they can still testify about treatment and everything else. Who's the final? There's one more motion to strike, correct?
Your Honor, we've got their retained testifying expert, Dr. Ongeko. Now, one thing I'd like to say before I talk about Dr. Ongeko.
Could you spell his name? Could you spell his name for the record?
It is Ongekeo.
Okay, go ahead.
Before getting into Dr. Ongeko's testimony, it is worth noting, Your Honor, again, in connection with causation, none of these experts, none of these doctors, dentists, or Dr. Ongeko have actually looked at or utilized a report, whether it's a lab report, or seen the list of ingredients that are in sucker punch or mother's milk. Plaintiffs specifically plead that the flavoring in those two e-liquids is what caused Mr. Harris's cancer. Nobody has looked at the list of ingredients, has testified about it, or has provided us with a report of what's in mother's milk or what's in sucker punch. They don't even have that. And so going back to the other two, I understand Your Honor is denying those motions, but I think it's worth noting none of them have looked at these e-liquids. And so they're jumping to a conclusion based on a lack of science, and they don't even have any evidence to show what's actually in these e-liquids. With Dr. Ongeko, question, do you have an opinion in this case, an expert opinion? Yes, I believe that electronic cigarette vaping used by Mr. Neil Harris contributed significantly to the promotion of the growth of his cancer and ultimately his death. I do not have an opinion whether it caused the cancer, but I think there's sufficient evidence to show that it promoted the growth of the cancer. Question, you're not going to testify that e-cigarettes caused Mr. Harris's cancer, correct? Yes, that's correct. Question, you are. Answer, but I am testifying that it promotes or promoted his cancer. Your Honor, when then asked what that meant, Dr. Ongeko admitted that promotes is a vague term. And it's because he has to dance around the fact that none of the studies that he reviewed and provided in his expert report actually come to the conclusion that vaping causes cancer.
I guess because if I recall correctly, the plaintiff also smoked for a number of years, isn't that correct?
Yes, Your Honor, and had HPV, which is a known risk factor in contracting oral cancer.
I guess I see that this is analogous to an asbestos case where you had somebody who smoked but also was exposed to asbestos and then is trying to claim lung cancer. I really think this is more of a jury issue, but as opposed to a motion to strike. But Mr. Bringan, what do you think?
Agreed, Your Honor. And the asbestos case is one example, or the breast cancer case where the doctor misses it. The doctor didn't cause the cancer, but the doctor failing to diagnose it caused the patient to die. So plaintiffs are proceeding on two different theories. One,
I don't see that as analogous. Are you saying that you think that's a better analogy?
I don't know that it's better, but it would just be another one and that's used to just distinguish between.
I just don't think that's because it's the doctor's not promoting. If I understand what he means by promoting, it's like he may have had underlying cancer that was accelerated or was, may have caused it, but it may have just accelerated, or it may have been combining causes. I don't see a doctor who's looking at a patient as accelerated, unless the doctor is doing something. I don't know how a doctor could cause somebody's cancer to be accelerated.
Agreed.
Like a situation where you have maybe multiple causes and you're not sure for sure which one caused it. That seems to be more analogous here, unless I'm missing something on that.
No, I probably misspoke on what I was trying to show with that. Okay. I'm saying that the plaintiffs are proceeding on two related but separate theories. One of which is the e-cigarette vapor itself was a substantial factor in causing the cancer. The other theory is that e-cigarette vapor was a substantial factor in causing the death. So you have cancer causing death. That's what I was trying to illustrate by that. But I agree. I think and
I'm not just saying that because I want you to choose my analogy, but I think that it concerns me you brought that analogy up because it makes me think I'm not really understanding what your argument is.
No, I think you do understand. I agree. I think your analogy is probably more on point for what we're trying to say here.
Okay.
Yes.
All right. Anything else on this one?
Well, Your Honor, it's, if they want to establish causation through Dr. Ongeko, it has to be a producing cause. He's not testifying to that. He's not stating that the use of the e-cigarettes was a producing cause of his cancer. Because the studies they talk about as well, Your Honor, I've heard about the Stevens study. None of these experts actually talk about it in their deposition. They're not talking about relying on it. They didn't testify about it. That's just attached to their briefing. When it comes to studies too, the Texas Supreme Court has held if they want to show specific causation through these studies, the studies must show at least a doubling of the risk of developing a condition after exposure. That's the Havner case. When asked, Dr. Ongeko, you don't have evidence of a statistically significant elevated risk that a person who uses e-cigarettes and already has oral cancer will get that, will have the cancer worsen because of the e-cigarettes. I do not have evidence. So even though he tried to say earlier that it promoted it, he then admits that he doesn't have the evidence to support it. They can't get to the producing cause standard here. And again, Your Honor, what they did during the deposition, and I suspect plaintiffs are going to mention this, for the first time, we got a report that was a purported lab test of what said it was an unknown e-liquid. And Dr. Ongeko said he had looked at it, didn't know who did it, didn't know who did the testing, was given it by plaintiff's counsel. And again, it says unknown e-liquid, but was told by plaintiff's counsel it was mother's milk, I believe. And wanted to use that at his deposition to support his conclusions as well, even though he had provided his report in May, was deposed to December 29th. And that was the first time we saw this report.
All right, I'm going to deny the motion to strike as to Ongeko. You said, is that all the motions today?
All of defendants' motions, Your Honor.
All right, plaintiff's motions?
Yes, Your Honor. Ms. Arledge is going to be arguing that for us.
Okay.
Yes, Your Honor. We have a motion to strike Dr. Amy Model, who's the defendant's retained expert. Dr. Model has two basic opinions. One, that the available analytical and toxicological studies of e-cigarettes shows risk of cancer from chronic use is low. Second opinion is that other risk factors, either independently or in combination with each other, like alcohol use or tobacco use, increase the risk of Mr. Harris's developing oral cancer and were the likely cause of his cancer. We believe that Dr. Model's opinions are unreliable because they're not grounded in MADL.
Okay, go ahead.
They're unreliable because they're not grounded in methods of science, and they're irrelevant because they're not sufficiently tied to the facts to be helpful to the jury in determining whether the e-liquid at issue here was effective. And just to kind of give you some bullet points of why we think they're unreliable and irrelevant, she doesn't know the ingredients of the e-liquid at issue. She doesn't know the ingredients in the e-liquids she reviewed in the literature. She doesn't know if they're the same as the e-liquid here in this case.
So let me ask you this, should I strike both plaintiff and defendant's experts or neither of them?
If those are my choices, I would say neither.
All right, I'm going to deny the motion to strike. What else do we have?
That's it.
All
That's it,
right.
Your Honor.
When is your trial setting on this case?
We're still set for the 23rd, Your Honor, of this month, but obviously that can't go forward.
Do you want to, I mean, I'm not going to, it's totally up to y'all. What I'm handling, how I'm handling most of these, I'm assuming this is a jury case, is I'm meeting with you on the day of the trial setting and just talking about when you want to reset it. If you're ready to, well, I don't have a lot of time. If you have a date that you've already discussed that you want to reset this to, I'm happy to do that right now so you don't have to come back. But if you haven't done that, we probably should just have you come back. But there's no way you're going to have a jury trial this month.
Yeah. I think we're set. You have a hearing set or some kind of a conference on the 23rd. I didn't know if that was to discuss the new trial setting.
Is that the date of the trial setting?
Yes, Your Honor.
Yeah. So what we do is we just bring every case in and we just talk to you guys. I will say this is that what is the cost number on this case?
2019, Your Honor.
It's pretty unlikely you'll get reached this year. I'm not saying it's impossible. So you might want to look at, January, February, March dates on my docket for next year. Unless there's some compelling reason to try to do this sooner. I'm guessing, you guys, your guess is as good as mine, but I'm thinking we probably will not be back to jury trials until this late summer or fall. And then we have, we've reset every week. I'm resetting 10 to 15 jury trials. So just be aware of that.
Yes, Your
So
Honor.
thank you, Your Honor.
So if you guys want, you might want to talk about this beforehand and just try to figure out dates that work and, check the online docket. Get,
We
yeah,
will, Your Honor.
Mr. Bringy, if you could get me an order on all of this, and I will go ahead and sign that by the end of the week.
Will
And
do, Your Honor.
email that to my court coordinator as well as e-filing it. And run it by opposing counsel.
Okay, will do.
Okay, guys, great to see you.
Thank
Be
you very
safe
much,
out
Your
there.
Honor.
Your Honor.
Thank you. All right, I see some folks here. Are you guys showing up from last week, Mr. Hurst and Mr. DuBose and Mr. Wide?
Yes, Your Honor, per Your Honor's instruction.
Okay, you guys are supposed to go to mediation, am I recalling correctly?
Yes, Your Honor.
And have you been or no?
No, I think Mr. Judge Wyden and I just agreed to a mediator and a mediation date, I believe, correct me if I'm wrong, with Judge Jordan the morning of February 19.
Okay. Is there anything else we need to talk about today?
Yes, briefly, Judge, I apologize, but pursuant to your oral directives on you
Let
told
me ask
the-
this before we do this. Mr. Moss, what are you here for? Oh, you're one of the parties, correct?
Yeah.
Okay, go ahead,
Your
Mr.
Honor,
White.
I'm sorry. Can we go on the record? I see Tony there. Is that okay? Or is it?
I don't have anything set for today, so I don't know what he's going to talk about. So I'm not sure why we're going on the record, so.
Me either.
Yeah, so
Okay.
if I'm, before I make any decisions, I'll go on the record, but I don't have anything set, so I'm probably not going to make any decisions today, but Mr. White, briefly tell me what you need.
you issued orders rescinding previous notices to show cause on
Right.
Mr. Martin, the judgment debtor. And I will note that his alleged wife's counsel is present, Mr. DuBose.
Uh-huh.
Mr. Martin was ordered by the court to provide dates to your coordinator no later than Thursday, February 4th, of within the next 30 days that he would be present, physically present at court for the
Let me
contempt.
do this. Rhonda, you're exactly right about that. Rhonda, can you come in here real quick?
Can I get the court to repeat what it just said?
What? To have
That I-
Rhonda come in here?
No, I was exactly right. I don't hear that too often sometimes, Judge. Kid, yeah.
I just don't know. I mean, to be honest, I don't know if Rhonda, he's contacted Rhonda. That's why I'm bringing her in. So
I certainly have not received any.
Nancy, do you want to get in on that? Thank you so much. Let me just check. He may have done that, and I just don't know.
And Judge, I only ask you because you're here, and I prefer not to wear out, my welcome with her. And obviously, you have way more cases and not near enough staff to handle so much of it. And just because we're doing everything electronically doesn't mean it's more efficiently either. So
Sure. Well, let me just find out. She can check her emails. He was supposed to email her according to my order, so I just don't know if he has or not. Hey, let me go on mute for a second.
Still not working.
Okay, so we are going to go on the record on this, pursuant to Mr. Hurst's request. Mr. Hurst, if you could announce the cause number of this case and the.
Yes, Your Honor. This is Michael Hurst and Paulette Miniter of the law firm of Lynn Pinker, Hurst and Schwegman. We represent the non-party Google and YouTube, another non-party. The case is DC 20-09893, Moss et al. Versus Martin et al. That, if I misstate anything, Judge White, I'm sure will tell me I did not.
Okay, Mr. Wide, you're here as well, and correct?
Yes, Your Honor.
And Mr. DeBose? You're muted, Mr. DeBose. You need to speak up so we can have it on the records. You need to unmute. Unmute. You're still muted. Mr. Moss, why don't you?
Okay, yes, I thought you had muted me.
No,
Yes.
I did not. I'm sorry. Mr. Moss, if you could state your appearance. You need to unmute as well.
Yes, I'm here, Your Honor.
So let me just do a summary of what's going on right now. So we
And
had
so
a-
is Mr.
Whoa,
Keating.
whoa. Mr. Keating, where's Mr. Keating? I don't see him, Mr. Oh, Brandon
Yep.
Keating, okay.
Those are my clients.
Mr. Keating, if you could state your name.
Brandon Keating.
Okay, so let me just summarize where we are right now. We had a hearing last week where I instructed the parties to come back today to discuss the possibility of going to mediation in this case. The parties have agreed to go to mediation with former Judge Jim Jordan on the 19th. So Rhonda, make sure that you send an order out to that effect. Also, I had previously issued a show cause order on this case for the defendant, Brian Martin. I was told that Mr. Martin had indicated in a prior hearing that he would not come to the United States. He has said that he's currently in the United Kingdom. So we had the hearing the day before I was going to, I had to look like I was going to have to cancel the hearing because of a conflict in my schedule. We usually have Friday hearing dockets are subject to trial. And we had a trial that carried over to Friday. And so I was going to cancel it. Anyway, I canceled it. Then I reinstated it when I realized he wasn't going to show, or he had represented he wasn't going to show. He sent an email to the court complaining that he could have shown for the hearing. And so I vacated that show cause order due to the confusion about it being canceled. I gave Mr. Martin an opportunity to contact my court coordinator to give us times anytime in the next 30 days that he would be available for an in-person hearing on the show cause hearing. He was instructed to contact my court coordinator, Rhonda Pinson, who is here. And Ms. Pinson, if you could state your name.
Rhonda Benson.
And Ms. Pinson, has he emailed you to or called you to give you dates that he's available to appear in person for the show cause?
No, he has not.
So subject to that order, I'm going to go ahead and set the show cause hearing on the court's docket since Mr. Martin has declined to provide us dates. Mr. Wide, I don't know if you need to be there for this, Mr. Hurst, but you can if you like. Mr. Wide, are you available on March 1st? For a show cause hearing. Okay, we're gonna go ahead and set this on March 1st. You need to just reissue that again. That's a Monday, so it will not be subject to other trials. I don't want to have to do this again. We'll set it at 3 o'clock, and that's it, guys. Thank you so much.
May I request that be a special appearance, a special setting at 3 p.m.?
What do you mean a special setting?
I'm just trying to, he's failed to appear for whatever reasons, at least on the 11th and the 22nd.
So on Mondays, my hearing docket is not subject to trial. On Fridays it is, and that's why it got canceled before. That's why I'm setting it on Monday.
Yes, sir.
Okay.
Your Honor, I don't. It sounds like you're ready to get rid of us, and I completely understand. If you want an update on the registry of the court, which you had discussed,
I would love an update on that issue.
Okay. So Google has initiated a wire transfer of $170,000, which is revenues from October through January. That's been done today. That's actually $170,340.19. And then there's going to be another wire transfer this week of $118,000, we believe, by the end of the week. And that there's part of it just took a few days to get some internal approvals. That will be the monies, approximately $290,000 that was earned from the 4 channels we've been talking about in your November 23rd order. I just want to let you know that those will be in there. Those will be in the registry of the court prior to the mediation between non-party Google and YouTube and Mr. Wyde's client, or Judge Wyde's clients. So I want
let me ask, can I ask a quick question? Because I want to maximize the chances this is going to work for the mediation. And Mr. Hurst, I don't know if you're able to disclose this information or not.
Sure.
And if you can, please tell me. I'm not trying to force you to do anything. Do you know who all the potential claimants, or however you want to, or potential owners of these funds are? Is it just Mr. and Mrs. Martin, or are there other potential owners? I know there's some complicated setup of how that exactly works within how there's, I forget what you call it. There was a term that you called with how these
multi-channel networks.
Multi-channel networks. Are there other folks that may be claiming this money?
We don't know for sure. My understanding is, and I'm visiting with Paulette here, we don't have any kind of notice that other people may be making claims to those monies. We don't know if the judgment debtors have made any assignments or purported assignments or anything to that effect. But my understanding is, and I can get clarification, is that we don't have any notice beyond the 2 people that you've stated.
Mr. and Mrs. Martin?
Yes.
What I know about that, George, about this is that Ms. Bones' money was going through a multi-channel network. The multi-channel network gets the money from Google. They take a 5% commission on that before they pass it on to her. So I don't know whether they're going to claim anything or not. Google has been threatening to take away all their business because of some of this stuff. And I'd like to talk to you about that, Michael, later.
So, Mr. DuBose, I assume that you'll be at this mediation, correct?
Beg pardon?
I assume, Mr. DuBose, you'll be at the mediation?
Nobody's invited me. I'm not sure. Yeah, I can be there. Certainly.
I want Mr. I very much would like, because he's also, his client's and also potential claimant to this money, correct? As
Yeah.
I understand it. So he needs to be there for this mediation to work, I think.
Okay. And what is the date, time, and place?
It looks like it's going to be a burden mediation, I believe, Judge Wyde, and that's on the morning of February 15. I'm sorry, February 19. Sorry, February 19. And it's Judge Jim Jordan, one of Judge Hoffman's former colleagues, who's going to be the mediator.
A fine judge and a fine person.
I served on one of his juries.
Small world.
They won't make that mistake again.
Mr. Hurst, was there any other update you'd like to give us?
We submitted 2 proposed orders pursuant to your honor's rulings from the last conference regarding the withdrawal of the turnover order and the ex parte garnishment order.
Okay.
And for submission, I'm not sure exactly what the proper vehicle is. We're submitting the funds to the registry of the court in the nature, it seems, of an interpleader. And I don't know.
That's how it sounded to me, is what essentially is going on. Maybe, have you thought about doing a formal interpleader action?
We have talked about doing a formal interpleader, but we've got, it just hasn't been done. But I think it seems to me that makes sense, that your honor would issue an order of interpleader that would require the funds to put into the registry of the court, because it's not really a garnishment, and we don't believe there should be that a turnover order would be the proper vehicle. It's really, I think, an interpleader.
Can I ask a question here that may not have an immediate answer, but it's maybe something you guys should think about, which is, so it sounds like there's about $270,000 that you guys have turned over that you agree that does not belong to YouTube and Google, correct? Mr. Hurst, your clients are not trying to make a claim on this money, right?
It's $290,000.
290,000, I'm sorry,
Yeah.
on that money. I'm wondering if, so just from a procedural standpoint, and I'm dealing with this issue in another case, so I'm kind of heightened sensitivity to this. So let's say there's other money that Google or YouTube has distributed, or they have in their possession that is kind of contested, that they think that they own, or that they've already distributed, maybe that Mr. Wyde's clients feel wrongfully distributed. I'm wondering if I don't know if the issue is making it clear, but like some of the money is clearly not claimed by Google or YouTube. And so that money can be interpolated, where there may be other funds that Google and YouTube say, hey, look, you guys don't own this, we own it. And then that money shouldn't be necessarily placed in the registry of the court. But you kind of see what I'm getting at here, or am I making that clear, Mr. Hurst?
I think so, Your Honor. I mean, I also want to state that my understanding is that all of the monies that have come in through those 4 channels in October through January are what's going to be interplayed into the registry of the court.
You're not holding anything back.
We're not holding anything.
But when did Google get notice of this judgment? Was it in October, or was it before then? Or do you know?
It was September 23rd, I believe. And so there is, and maybe this is something we're going to have to just discuss at the mediation there, between September 23rd and October 1st. Those monies, I don't know that were trapped, because it's on a subsequent month basis that the monies are distributed. So the September monies, the wheels may have already been in motion. And I have more detail on that, but that's something we could discuss potentially at mediation, or I could go into whatever detail I have on why it is that the monies between September 23rd and October 1st, or September 23rd and September 30th may not have been trapped.
Your Honor,
May I address?
No, not yet. Mr. DeBose?
I learned a lot about this from the fellow who's the network group. The way that Google works is money comes in. They advertise on the various channels, and then money comes in from the advertisers, and this is the magic word, an algorithm which determines how much of the money that came in from that advertiser, who's advertising all over the place, is money that is attributable to that channel. My understanding is that Google takes the lion's share of that before sending out what it sends out to those people who are listed as the owner. The owner of a channel is a highly mythical figure. There is no contractual obligation that YouTube has to pass the money on. It's very clear in their terms of use. It is something that they do out of the goodness of their heart. It's simply the way those channels work is people look at them as long as somebody is putting up and people follow them. And when a new video goes up, then somebody clicks into that channel, and there's a click that goes out to all the advertisers. What's happening now to these channels now is, of course, Holly is not participating in putting anything on those channels because she's not going to get anything back. And believe me, those are hers. And Google's records show that the only owner ever of those 2 channels is Holly. And I am wondering whether, before we go much further, Google is willing to respond to some discovery of documents. I've got documents, and I've got an affidavit from George Venice, who operates the network, which says when he goes in and puts her into the system, the system automatically pays the money to her because it's connected to the ownership files of Google. She can't click into it. And so much of this is clicks and not signatures, but he can't click her in as the owner unless Google's great computer machinery has determined that she is on their records what they refer to as the owner. I am thinking Mr. Venice has been enormously helpful to me in understanding all this. And I'm wondering, I think he'd be glad to sit for a deposition or anything that people want. I mean, I've talked to him about
This
this.
guy works for Google. Is that who this person is?
No, he is a completely independent operator. What he does, he's got 1,700 channels that he works, and what he does, he advises them. He says, it puts music in. A lot of these people don't really have much sense of all the values that can be put into, in terms of quality of picture, quality of sound, all those things. And he does that. And he took Holly on, a year and a half, 2 years ago. And at that point, her income shot up substantially. And most of my understanding about this comes from George, who's been working with this stuff for some years. He's the CEO of that particular company.
I'm not going to require anyone to take his deposition if somebody feels like they want to. That's up
No,
to them.
well, I may well want to depose him on my own, but my question to Google is, are you willing to respond to some discovery on a very quick basis as to what your documents show who the owner is of the channels? Michael, Mr. Hurst?
You're asking me whether we would do discovery within the next week or so on for the purposes of. No, I can't commit to that at all. And I don't think that's appropriate. If you want to, talk to me about it after the hearing or something
Okay.
like that.
I'll talk to
happy
you.
discuss
Not a
it
problem.
with you, but I can't imagine
I agree with
that we're
Mr.
going to
Hurst. I don't
engage in
think it's
discovery
appropriate.
with you and your client prior to a February 19 half-day mediation.
May I point out, Judge, two matters?
Just 1 second. So, Mr. Hurst, I will say this one thing, which is the issue here. This is exactly kind of where I wanted to get to ultimately. So I really appreciate you facilitating this and moving this forward and getting us kind of in the direction of where this eventually needs to be. The big issue now is going to be who actually, now that we have the funds, apparently, it's who actually owns them. And so at some point, there probably is going to need to be discovery between Mr. White and Mr. DeBose's clients and Google to make that type of determination. And so I'm not saying that you have to do it now or you have to do it in a week, but in my mind, as I've been dealing with this for a number of months through a lot of unnecessarily difficult proceedings. It would be great to get Google's not position. I mean, Google doesn't make this ultimate decision, but their documents that would show that issue maybe before that. Maybe it would be better to move the mediation, because that is going to be the real issue here, is who owns this. Is it, because it really isn't a fight between Google and the plaintiffs. It's a fight between the plaintiffs and Mr. DuBose on this issue. Does
Yes.
that make sense?
I agree, Your Honor. And if we're going to deal with those issues at the mediation, I certainly would like opportunity to take some of that discovery.
It's up to y'all. I mean, I do think Mr. DuBose has a point that is, now that we've identified the funds, which was so critical in this, and Mr. Hurst, again, we appreciated that. It's getting to the point of figuring out who owns this. was there some, and Google's kind of, it is a player here. They're going to have documents that showed potentially, okay, from the beginning, this was owned by Miss Martin, or, was it owned by Miss Martin and then transferred to Mr. Martin? Or was it owned by Mr. Martin and transferred to Miss Martin? All of that kind of stuff is really critical to the eventual resolution of this matter.
My
excuse me.
understanding, my understanding is that she has owned them from the start, and I have some corroborating documents on that.
I don't know if that's true or not. I'm just saying that.
I can help clear this up a little bit, Judge, if I could.
Mr. Wise, you've had a lot of chances to talk in this case, more than, and so.
Well, Judge,
you could, I'm not making any decisions today. I'm just trying to help Mr. Hurst
understand. I wanted to correct something for Mr. Dubos's possible misunderstanding. At the temporary injunction hearing back in October, the court had documents that were admitted into evidence from the Texas Secretary of State's office, as well as the testimony of then Brian Martin's wife, if you will, when the channel was created. That's one. I don't know if Mr. Dubos is aware of that or not.
I'm aware of it.
Okay. Well, then two, it is obviously a fraudulent transfer case, and we've alleged that anything that Mr. Martin owned has been fraudulently transferred, but including these channels. But number three, Judge, we have a problem because with Google, while I'm extremely grateful to Michael for getting that money interpled now after 4 months, give or take, my comment to you is we believe the channels are intellectual property, which are exempt from the Texas Property Code and executable on. Google has a license with those channels. Now, the court issued a turnover order applicable to the judgment debtors. We haven't.
They also want to exercise ownership over those channels. Is that what you're getting at?
Yeah.
Yes, and the problem becomes, how do you execute on intellectual property? And obviously, Michael has said, look, we're not Google's position. And I read the case law, and I think that's a reasonable interpretation of some of the case law, that they're not subject to a turnover order because they're not a judgment debtor and they weren't a party to the prior underlying litigation. And the statute was rewritten in 2017, if I'm not mistaken, pursuant to the case law that was provided, Beaumont Bank and some of the others, that turnover is really limited nowadays after 2017 to these people who were judgment debtors and parties to the underlying litigation. So how do I execute on behalf of my clients on intellectual property? I can't send the sheriff to Google in San Bernardino County to get the channels. And this is going to be a problem in the case because it's the channels where the value is, not which generate the revenue. And I wanted to put that out there to the court to let you know that's what we've pled for in our prior pleadings.
That's a good point. That is a good point you raised, Mr. White, and that's something else that is probably going to be a good subject to talk about at the mediation between the three of you guys. Is there a way to transfer ownership to the plaintiffs in this case, or what is the value of that asset? Because it's not just the revenues, it's what's the value of the asset that needs to be determined potentially in this case. And so I do think he raises a good point as to that issue.
And my last point,
Your
Judge,
Honor, if I may.
I apologize. My last point.
Guys, I'm not making any decisions today.
I know, but there is a temporary injunction. There's a temporary.
Well, it's so good to see you guys. I appreciate it. Good luck at your mediation. And we are done for today. Mr. Hurst, did you have any more questions before we finish?
No, thank you. I'll talk to Mr. DuBose afterwards. I was going to ask him if he's got this corroborating stuff on ownership, maybe he can send that to us. That might be a good. Okay.
Thank you, guys. You have a good day, okay?
Thank you, Your Honor. Have a great week.
Thank you, Your Honor.
Thank you. All right, we're letting to the next case.
Can you hear me, Your Honor?
I can. I saw Ms. Jones as well. I thought I'd already ruled on this motion. I was a little surprised to see you guys.
You want me to respond, Your Honor? I don't want to what?
No.
Okay.
No, I'm just asking Ms. Jones, is there some, I guess, when I saw this, I'm like, it kind of in my mind, my part was done. I thought you guys had appealed this, so.
Judge, it's more formality, I think, than anything. We had filed a motion to set aside the judge for,
Okay,
ruled on. This is a motion for a new trial. So now that you have signed the order, we have filed a motion for a new trial. I do understand that substantively it's the same issues and we have already filed the appeal, but as a formality, we have also filed this motion trial.
all right, so just, I don't know that you needed to do that, but in abundance of caution, it's kind of belts and suspenders if you want me to deny that as well, or I know you don't want me to, but if I need to rule on that as well, I'll go ahead and rule on that. Did you already submit an order for me?
Your Honor, my only statement to the court is the 105 days, the judgment was signed, ran on January 21st. So
Okay,
I don't need,
have plenary, do I not have plenary jurisdiction at this point?
that's my statement, Your Honor. So you don't.
Then I can't even sign it. Is that right, Ms. Jones? Do I not have plenary jurisdiction?
Judge, we asked for a hearing as soon as the court was available, but we are also of the opinion that at this point you don't enter a jury.
I wish you guys the best of luck, Ms. Jones. As I've said before, I always, I feel really bad at what happened in this case in terms of, I think there were two innocent parties that got hoodwinked and the jury went with what they did. And so I really do wish you the best of luck in the future. I hope it all works out. And this is one case where I wouldn't be sad if the Court of Appeals disagreed with the jury here, but I don't feel comfortable overturning the jury's verdict on this. So I wish you the very best of luck. Okay, Ms. Jones.
Understood, Judge. Thank you.
Mr. Laird, good to see you as
Mr.
well.
Laird.
I thank you, Your Honor.
Thank you. That's it, guys. Be safe.
Thank you.